Welcome to Beyond the Curve, providing strategic insights on international business and international law. Today's program is being brought to you by Institute for Supply Management Corporate Program. You can learn more about ISM at ism.ws. I'm Jeffrey O'Brien, alongside my co-host, Dr. Adriana Sanford. Dr. Sanford is a clinical assistant professor of business ethics and law in the management department of Arizona State University's W.P. Carey School of Business. She has 6 years of law school, including a double LLM in taxation and international comparative law from Georgetown University and a law degree from Notre Dame. She has 4 languages under her belt: French, Spanish, Portuguese, and English, and has represented numerous multinationals, serving as both in-house and external primary U.S. counsel. Good afternoon, Dr. Sanford.
Good afternoon, Jeffrey.
Today we'll discuss the compliance and ethical challenges facing our global supply chain, the use of whistleblowers and international conventions to obtain evidence, as well as examples of the simultaneous prosecutions under corruption, tax evasion, and money laundering.
One of the big problems that face companies today is when executives don't understand the impact of their actions. Believing that the consumer is unaware of how products get to market, they often cut corners, not realizing the price they'll have to pay later. Recently, the public has actually become aware of some of the problems and the dangers of an unethical supply chain. There have been a series of publicized problems, such as unsafe cars, lead paint in toys, and let's not forget the tainted dog food and the toothpaste. Companies today have to take action and be more stringent in their processes. There's a high demand for accountability, particularly when a great deal of your manufacturing takes place overseas.
So what steps are multinationals taking in this regard?
Now, what we're seeing more and more is that companies are actually taking a stand and they're implementing a compliance and ethics program. They're training their employees, but they're failing to take it to the next level. They're actually not taking it to the global supply chain. So their suppliers, their manufacturers may actually be involved in unethical behavior, and the company at the end bears the burden.
Is there anything multinationals can do to protect themselves?
There are actually some companies that are looking at ways of designing or implementing what we call the supply ethics management, SEM. There has actually been a group of global companies who have actually come together and put a program in place that allows them to track and to monitor their suppliers and actually be a little bit more involved with regards to their global supply chain. SEM is actually a relatively new business practice. The goal is just to reduce the overall risk of corporate integrity failure through strategies, programs, and metrics that actually better align the supplier's business conduct with the purchaser's standards in 3 major corporate integrity areas, which are compliance, ethics, and corporate responsibility.
Could you give us an example of an effective SEM program?
An effective SEM program would include knowing the compliance history profile of your important suppliers and making sure that you assign a compliance and ethics personnel to major supply relationships. Another step is targeting and segmenting suppliers by importance and by ethics risks. With the escalating rate of enforcement by both U.S. regulators and overseas officials, multinationals really can't afford not to include their suppliers in their ethics and compliance programs. I'll give you an example. One of the big problems we're seeing right now are multinationals being charged with corruption, with foreign and corrupt practices violations, and bribery. And when this happens, actually, oftentimes it's not necessarily going to be recorded on the books. As a result, the companies are also being charged with tax evasion. Today, there's a global trend towards the criminalization of failures in tax compliance. And so those that specialize in tax law actually also need to have knowledge of other areas of law, including criminal law, money laundering, asset forfeiture, and international evidence gathering.
Well, we're going to take a break. When we come back, we'll have our guest, Dr. Bruce Sagaris, talk to us about simultaneous prosecutions under corruption, tax evasion, and money laundering. We'll be back with more Beyond the Curve after this. Today's broadcast is brought to you by Institute for Supply Management. Institute for Supply Management, a history of leadership. ISM is the first supply management institute in the world. Founded in 1915, ISM exists to lead and serve the supply management profession and is a highly influential and respected association in the global marketplace. By executing and extending its mission through education, research, standards of excellence, and information dissemination, including the renowned monthly ISM report on business, ISM maintains a strong global influence among individuals and organizations. ISM is a not-for-profit educational association that serves professionals with an interest in supply management who live and work in more than 80 countries. ISM offers the Certified Professional in Supply Management qualification and is a member of the International Federation of Purchasing and Supply Management. ISM is proud to bring you this broadcast highlighting key issues and trends affecting supply management and the current business environment. Discover how to ensure your supply organization is prepared for the future and gather intelligence to shape your decisions and plan for the future success of your company and your career. For more information about Institute for Supply Management and the ISM Corporate Program, visit the ISM website at ism.ws or call the ISM office in Tempe, Arizona at 480-752-6276. You can also find ISM contact information in the resources section of the Beyond the Curve website, beyondthecurveshow.com. Welcome back to Beyond the Curve, providing strategic insights on international business and international law. And now joining us on the phone from Washington, D.C. is Dr. Bruce Sagaris. Dr. Sagaris is a world expert on international financial crimes. He's worked as a consultant and counsel for 14 governments and the United Nations on tax enforcement and international criminal law issues. He's a distinguished expert with decades of experience in criminal trials and consultancy work for the public and private sector. He's testified as an expert witness in complex cases involving corporate whistleblowing, international tax schemes, money laundering, bank fraud, and other international white-collar crimes. He's authored and edited hundreds of articles and several books on international law, including his latest book, International White-Collar Crime. Dr. Sagaris, could you share with us some recent developments regarding international tax enforcement and the simultaneous prosecutions taking place?
One of the very interesting developments that we have, Jeffrey, is that on February 16th, for instance, the Financial Action Task Force issued revised anti-money laundering recommendations, and they require that countries criminalize as money laundering all serious tax crimes. They also require much more detailed initiatives against transnational corruption, meaning that banks and financial institutions have to do more to prevent politically exposed persons from using their banks and financial institutions. And we see now that the U.S. government is moving on all these fronts. So, for instance, just in March, the Treasury issued an advance notice of proposed rulemaking on tighter customer due diligence. And that will require banks and financial institutions to do a lot more to know what their customers are doing so that they can prevent money laundering, tax crimes, and also combat corruption. In addition, Congress has already in 2010 enacted a new law, the Foreign Account Taxpayer Compliance Act, which requires U.S. taxpayers that have foreign assets abroad to file annual reports on such assets, or if they don't, they face huge penalties, and the statute of limitations won't even start running until they file these reports. In addition, this law, which has the acronym FATCA, requires foreign financial institutions to search their records and find whatever U.S. taxpayers that they're doing business with and to report that information directly to the U.S. Treasury. In addition, Congress has other proposed initiatives such as the Incorporation Transparency in Law Enforcement Assistance Act, which will require states like Arizona to enact laws that require persons who form corporations to report information on the beneficial ownership of such corporations and to file supplemental reports anytime there are changes or annually. So there are all kinds of very dynamic developments internationally and in the U.S. on federal and state levels with respect to transnational corruption, anti-money laundering, and tax enforcement. This means that private sector now has to do more to undertake due diligence, or else they will face the consequences. Another example is recently on August 16th, U.S. District Court in Phoenix sentenced an Arizona man to more than 15 years in prison for conspiracy to commit money laundering and defrauding the Internal Revenue Service. So you see that there are examples on both the executive, congressional, and judicial levels on enforcing these converging laws.
Thank you, Bruce. There is certainly continuing convergence. In the current business environment, the integrity of the supply chain can no longer remain just a marginal concern. We're also actually seeing several international organizations taking a strong position, and the UN, the World Bank Group, and Interpol are continuing to play significant roles.
Is there anything else multinationals should keep in mind when they're handling these complex issues?
Today, whistleblowers have become a key element in international tax enforcement. We see more and more legislation protecting whistleblowers. For example, in July of 2010, the U.S. signed into law the Dodd-Frank Wall Street Reform and Consumer Protection Act. One of the most important aspects of this new legislation was the financial incentives and the protections for whistleblowers who report violations to the SEC. These new provisions are probably going to bring new whistleblower actions dealing with tax crimes. And many companies are looking a little bit more closely at their reporting mechanisms and perhaps themselves providing stronger incentives for those who report internally so employees don't feel the need to go outside of the organization.
Well, couldn't that create a huge problem for the employee?
Clearly, it's in the company's best interest to respond effectively to an investigation arising out of a whistleblower report, especially today.
All right, we're going to take a final break, and we'll be back to talk about some strategic steps in organizational management that'll help you navigate these murky waters. Beyond the Curve returns after this. Today's broadcast is brought to you by Institute for Supply Management. Membership, knowledge, insights. Supply management is unique. It's diverse. Supply leaders must be problem solvers, business partners, resources, conduits, oracles, and talent developers. As the first supply management institute in the world, Institute for Supply Management understands and embodies these imperatives. They are a dynamic, flexible organization committed to helping your company build a successful future by exploring the business environment, providing a solid foundation of professional development and fostering networking as well as relationship building opportunities. The ISM corporate program features a wealth of benefits to help your supply management team and company maximize their effectiveness and succeed on a global scale. The program provides unique leadership and skills enhancement opportunities, creating an environment in which your supply chain professionals can be more effective. It offers a straightforward way to provide your employees throughout your company and its wholly owned subsidiaries with the benefits of ISM membership, including access to professional development opportunities and members-only access to ISM's expansive database comprised of current leading-edge articles, presentations, conference proceedings, and other content offered by foremost experts in the supply management field. Gain a competitive edge in the market and invest in the future of your organization by enrolling in the ISM corporate program today. For more information about Institute for Supply Management and the ISM corporate program, visit the ISM website at ism.ws or call the ISM office in Tempe, Arizona at 480-752-6276. You can also find ISM contact information in the resources section of the Beyond the Curve website, beyondthecurveshow.com. Welcome back to Beyond the Curve, providing strategic insights on international business and international law. So, Dr. Sanford, let's discuss some new strategic roles emerging in companies with extensive overseas operations.
We see the role of the CECO is changing, and with many organizations, the Chief Ethics and Compliance Officer is actually a new face on the senior management team. Before, what would happen is the CECO would actually report to the General Counsel, or the General Counsel was actually the CECO as well. Over the years, we've realized that there's actually a conflict of interest and that these two positions should be separated. The CECO should be reporting directly to the board.
So why is this so important?
We found that when the General Counsel was actually the CECO, or when the CECO reported to the General Counsel, it often weakened the effectiveness of the compliance process and the multinational's ability to comply with U.S. and foreign legal obligations, such as the U.S. Foreign and Corrupt Practices Act, as well as the U.K. Bribery Act. This issue actually received quite a bit of attention in the resolution of various high-profile cases, and where multinationals had to actually agree that their CECO would neither be nor be subordinate to the GC or the CFO. So whether due to proactive strategic vision or reactive necessity, we're seeing a lot more independence between the legal and the ethics and compliance functions. And this is really critical, especially in countries where you're dealing with quite a bit of money laundering, crime, or corruption. With that in mind, we're finding more and more CECOs have a strong background in law, have a strong background in international matters, And this helps tremendously when you're dealing with ethics and compliance violations in other countries. Another position which is continually evolving is that of HR. We're seeing more and more IHRM, which is International Human Resource Management. And because whistleblowers, sometimes the first person they speak to is HR, we've seen that sometimes HR does not have the knowledge or the wherewithal to deal with complex international issues. As a result, it can be very frustrating for an employee who's trying to tell the company, trying to disclose some of the unethical or bad behavior that's occurring overseas. Companies that actually have an IHRM have a better ability to deal with these problems. A growing trend with quite a few multinationals that are faced with critical international issues is to appoint to the top level of HR an individual who specializes in a different practice and who can actually steer the expansion of the global operations. This is often an individual who understands laws, international relations, and organizational development, and possesses more of a global mindset and cross-cultural competence. An individual in this type of a role has actually more of an ability to handle ethical and moral issues arising from overseas operations. They can actually handle conflicting legal or cultural standards, as opposed to somebody who only focuses on domestic issues. So what we're seeing is if we have a general counsel that understands international issues, as well as a CECO and an IHRM leader, we have sort of a checks and balances within the organization, within the multinational. And as a result, they're having less issues with governments. They're able to handle their problems a little bit better. And also, if the company has an SCM program in place, it greatly reduces the risk of corporate integrity failures in their supply chain.
Well, that's fascinating stuff. That's all the time we have, but to hear more about these topics and other topics regarding the global supply chain, join us on October 29th for a special webinar. Be listening here in a moment for more information on how to do that. Also, be sure to join our friends at ism.ws. We'll see you next time right here on Beyond the Curve. We welcome ISM corporate program supply leaders to today's broadcast. For more in-depth analysis on these issues and other hot topics, join Dr. Adriana Sanford, Clinical Assistant Professor of Legal, Ethical, and Regulatory Issues from the Management Department of Arizona State University, W.P. Carey School of Business, and special guest Dr. Bruce Sagaris, a D.C. attorney, author of International White-Collar Crime, and editor of the International Enforcement Law Reporter, for an ISM webinar on October 29, 2012. Discussions will include an overview of the use of forfeiture to freeze assets early in tax and other cases, the increased prosecution of banks and intermediaries for crimes arising out of abusive tax planning, as well as risks associated with servicing the accounts of politically exposed persons. This ISM webinar is an exclusive product for supply leaders in the ISM corporate program.